Hi, and welcome to another edition of the Trustcast Show. And we're really happy to have with us Lorna Griffin. Welcome to the show, Lorna.
Thanks for having me, Zane.
So, Lorna has originally spent years inside the HR world, watching how companies operate, how they document, and how they protect themselves. And then went to law school to take all of that knowledge to the other side of the table. Lorna, when you're working in HR, was there a moment where you saw an employee get treated in a way that you knew was wrong and thought somebody needs to fight back?
Yes, that happened. I spent 16 years in human resources, and and an employee had come back from some pregnancy leave, and all of a sudden, the company started to push her out and started to make things difficult for her. I knew it was related to her pregnancy leave. There were conversations like she's going to have to start to take more time off. And it's very common for new parents, those conversations to be held in the workplace. And that never sat right with me. And now I get to do something good about that in situations like those.
So, um, you described law as your second career. What did working in HR actually teach you about the way employers think that you couldn't learn in law school? A lot of people think HR is, on their side as an employee.
Well, many human resources professionals they want to do the right thing. They're good people. They're trying to get along within the company and navigate employment for themselves. So for the most part, I do know that many HR professionals are trying to do the right thing, but whether they carry out the law in a manner that's not only fair but lawful is a different story.
So, I just got fired. I have no idea if it was legal. What's the first thing I should do?
The first thing you should do is call an attorney who practices employment law. I mean, there are many attorneys out there. Um, in Texas, attorneys can practice any type of law that we like as long as we do a good job. But an employment attorney is aware of an employee's legal rights, the status of the law that's always changing. So, consulting with an attorney that practices employment law can give you a sense of what's actionable, what's not, and provide some next steps on best possible outcomes.
So, everyone says that Texas is an at will state and my employer can fire me for anything. Is that actually true?
For the most part, yes, it is true. An employer may fire an employee for any reason except an unlawful reason. So
Unless they can't.
think the discrimination, age, race, religion, disability, medical leave, gender. An employer may not dismiss an employee for one of those reasons, or if they've participated in some sort of protected activity, that might be an unlawful reason to dismiss an employee.
Okay, so how long do I have before I lose my right to do something about what just happened to me? Is there a window of time?
There is a window of time for employees. I usually recommend that employees take action within at least 6 months, 180 days. There are state laws that mirror federal laws, and all of those have different timelines. So, federal law is 300 days, state law at least 180 days. But for some other protections like whistleblower activity, there are very short timelines, 60 days, 90 days, that have very tight filing requirements. So, as soon as an employee thinks that they're in some sort of questionable situation, they really should get some legal advice quickly.
So, a lot of times, an employee gets into a situation and they think, they know something is wrong, but they're scared to even seek legal advice because I'm sure you see this where they're afraid to even talk to a lawyer because they think somehow this is going to go back to their employer, and then they're going to lose their job, and it's going to be the worst day of their life. So how do you address that fear?
Well, it is very scary speaking up, and as soon as I mean, employees feel like as soon as they say something, now they have a target on their back. If they seek advice with an attorney, those conversations are always protected by the attorney-client privilege. So there's no way that that can get back to the employer. And, a large part of our practice, we speak with employees who are in that very situation. They're worried about their jobs, they're worried about next steps. And speaking with an attorney can kind of, well, advise them of their legal rights and provide some advice on best steps to take while they're still on the job.
So, do you do a, a no fee consult, or is there you have some sort of a fee to come in and just sit down and kind of discuss over a situation?
Well, like most lawyers, it depends. And this is why people hate lawyers because their answer frequently is it depends. Yes, we do offer some limited, no charge consultations, but it really depends on the employee's particular situation. When someone contacts our firm, my staff does a very thorough process of seeing, exactly what type of issue that employee is experiencing and gets it over to me as the attorney to review that situation. And then we decide what type of consultation is appropriate for the next step.
Okay. So, if I think I was fired because of my race, my pregnancy, my disability, what's the first legal step I have to take, and why does it matter?
Well, it matters because before, with employment claims, before the employee can go straight to court, they must file through the EEOC first, the U.S. Equal Employment Opportunity Commission. And you don't need a lawyer to do that. We handle EEOC representation, but the first step is to file an EEOC charge because that gives the agency an opportunity to investigate the employer. And most importantly, EEOC issues the right to sue. So the employee needs that golden ticket before they can file suit.
So, a lot of people think, okay, I lost my job. I want to keep it on the down low. I don't think my other employer is going to say something bad about me that may not give me a recommendation, or maybe they said they would give me a recommendation. Um, yeah, um, and I just got fired, and I think it was unjustified. Um, and then they say go to EEOC, and then they're thinking, if I go to EEOC, then that's going to go back to my former employer, and it's going to ruin my reputation, and it's going to follow me for the rest of my career. How does that all work? So, how do you kind of allay those fears? Because these are all real fears that I'm sure you've heard this over and over.
That is a huge concern, and it's a valid concern. Nobody wants to be bad-mouthed to a subsequent employer. Um, it's a huge concern. So what I will say is that the EEOC, well, the law prohibits retaliation from an employee who participates in protected activity like filing a claim with the EEOC. So this means that an employer can be punished even further if they're bad mouthing or talking negatively against the employee in order to, like torpedo them from a potential job offer. What we can do in many instances is negotiate a neutral reference with the old employer, so the employer is only permitted to disclose position and length of employment with the company, and they're not allowed to say anything else about that employee.
Hmm. So I know a lot of employers just do that as a matter, even if they're going to give a good recommendation, they don't give any recommendation just because of that very issue. So, is there anything an employee almost always does in the first 48 hours that makes their case harder to win?
When an employee resigns, it makes it incredibly difficult to proceed on a legal claim because the employer has a defense to say, look, we didn't fire that employee. They quit. They had an open offer of employment and they decided to quit. So before resigning, think about it or consult with an attorney so you can figure out your best options. But also, um, certainly, um, taking anything with you that belongs to the company could get you in some hot water. Speaking publicly may not enhance any legal claims that you might have. So I would consider speaking out on social media or speaking out publicly if you think you might have some legal claims against the company.
You would advise someone to do that
I would
or not to
advise
do that?
someone not to do that until they speak to
Okay.
someone.
Okay, I got it. Yeah, okay, that makes sense. So I reported my boss to HR 3 months ago, and now everything is different. Worse projects, bad reviews, left out of meetings. Is that legally classified as retaliation? And what do you do about that? So you went to HR, you filed some report. The boss was, I don't know, may have been, whatever. It could be a sexual thing, could be something else, just general harassment or making it a hostile workplace. And now everything is completely changed. Is that considered retaliation?
Well, it depends on what the initial report was about. If the initial report was protected activity, those protected statuses, age, race, religion, disability, medical leave, gender, if the complaint had to do with one of those protected statuses, the retaliation might be unlawful. But otherwise, I call it plain vanilla retaliation. That's not protected under the law. The courts say, at least here in Texas, that employers may conduct their workplace as they see fit. And if that's a personnel issue, favoritism, things like that are not protected under the law. And employers, if they choose to have a supervisor retaliate against its employees, the courts are not going to help with that.
Wow. So that's more of a Texas thing.
Certainly.
So if I make a formal complaint about harassment, am I going to make my situation worse? I mean, should I? So if I feel like I'm being harassed at work, should I go to HR and just complain, or should I go to an attorney and say, uh, what should I do?
Well, as I mentioned a moment ago, personnel issues are not generally not protected under the law. So if the harassment is based on a personality differences, like, oh, my supervisor just doesn't like me, or I have a new supervisor and they just don't like me, they're making my life hell. That is not, that should, that should certainly be reported to HR. And I think HR should manage those concerns. And those are employee vibe issues that they should be concerned about in the workplace. Um, the employee can always get a legal consultation so they know what their legal rights are. But an attorney will only an attorney can advise the employee on their legal rights if it's that protected activity we talked about.
So is there anything such thing as a hostile work environment in Texas?
There is, if it's related to one of those protected class statuses. So, say the employee reports race discrimination to HR and their supervisor, and now the company starts papering the file, puts the employee on a performance improvement program, a PIP, starts
Yep.
documenting deficiencies that weren't there before. Now it looks like that is a hostile work environment followed by the employee's protected complaint, and that could be unlawful.
Hmm. So my harasser is a peer and not my boss. Does the company have a requirement to do something about that?
Well, it depends on what type of harassment is. It is. Here in Texas, we have the standard that's severe and pervasive, not severe or pervasive, but severe and pervasive. Many of the conduct, harassing conduct, is actionable if it's a supervisor, because the supervisor can control your pay, can control your hours, can hire and fire. A peer doesn't have that power. So it makes it difficult to have potential legal claims against the company if the harasser is a peer. But
Mhm.
if the company does nothing to stop that harassment after it's been reported, then it starts to look like the company has an issue, and that would warrant a closer look by an attorney to know to look into specific details about the case.
Okay, so I have some rapid fire. I like to do rapid fire to just kind of break things up. So, what does Lorna Griffin do on a Sunday morning when she's not thinking about anyone's employment case?
I'm making breakfast for myself and the family, taking the dogs for a walk, and otherwise relaxing for the day.
What kind of dogs?
We have a Rottweiler mix and a Pitbull mix, and they're my first dogs in life. I didn't have never had dogs, and I never knew what I was missing.
Yeah, okay. So your husband Trey, your kids, and a son in the Air Force. What's the Griffin household feel like on a loud weekend?
On a loud weekend, well, I have to say the kids are all working and they're all very busy, so our weekends at the Griffin household can be quite quiet on most days, but when everyone is here, it's so nice and warming to have everyone together and to spend time together, and, the kids still give each other a little heck every now and then, so that's nice too.
Yeah. So, what's the one phrase employers use that makes you immediately suspicious?
Legitimate non-discriminatory reason for termination.
So, severance agreement or wrongful termination lawsuit, if you had to pick one to fight for the rest of your career, which one?
Severance
And why?
agreement. Because severance agreements are easier to work out between the parties because there's already an agreement, but enhancing an agreement that works for both parties is a little bit better.
So, if my employer just handed me a severance agreement and said I have to sign it by Friday, um, do I really have to decide that fast?
If you are under the age of 40, most likely yes. If you are over the age of 40, an employer must give you at least 21 days to consider that employment agreement.
And so, why do they have that?
As part of the Older Workers Discrimination Act,
I resent that phrase.
for those of us over the age of 40, our lawmakers thought maybe we were so feeble-minded, we needed the extra time to consider, but that's the law. So under the
Okay.
age of 40, they can give it an extremely tight deadline.
So, what am I actually giving up when I sign a severance agreement?
It depends what the contract says. Most severance agreements is a full release of all claims. Any and all claims you could ever have against the employer. That's what you're giving up in exchange for some money. That's usually well, that's usually what's contained in a severance agreement.
Are those so if I have a severance agreement, are those always enforceable? Because what if the severance agreement follows one of those classified acts which are considered illegal, and then you sign the severance agreement because you want to get out of there so bad anyway? Um, do is that really actually enforceable?
Severance agreement? Yes, they are enforceable. I have had clients come and seek consultation because they felt like something was not right. There was it that they experienced a wrongful termination, but they've already signed a severance agreement where they waived their rights. There's no getting out of that. That is a ironclad contract between the employer and the employee. And I mean, 99.9% of the time they're out of luck.
Wow. So even if they did go into it, basically you're giving them a free waiver, free lunch.
1,000%. Yeah.
Yeah. Yeah. So what's the single most dangerous thing you see people sign away without realizing it?
All of their rights, all of their rights. And sometimes these severance agreements have a non-compete or non-solicitation agreement tied in, wrapped into the severance agreement. And the employee signed it, agreeing not to work in the same with a competitor for 12 months, 24 months. And now you're barred from working in your industry for 12 or 24 months. That doesn't make sense to me. That doesn't resonate, but those agreements are enforceable.
So let's say you have a situation where someone gets a severance agreement. The boss, they say this is Texas is an at-will state, and here's your severance agreement. Sign it, or you lose the ability um, to. We're offering you this now. You have to decide immediately. So if you're under the age of 40, that's perfectly fine.
Yeah, so we get phone calls often where the employee says, "Oh, I need this signed by Friday. Can you help me?" And sometimes we can't get, as attorneys, we can't get to them by Friday. It's perfectly reasonable to ask for more time. I respectfully request an extra 14 days to review this agreement. I really need some legal counsel, or I'd like to have legal counsel and I'm still looking. So it's perfectly reasonable, and most employers will give the employee that additional time. If they continue to press the employee, then your options are limited and you have to decide, is the amount of money that they're offering in exchange for a full release after you've read it carefully, is that worth your while? Most of the time it is.
So so if I took an FMLA leave for a health issue, came back to work, and within 2 months was put on a PIP. Um, is that a coincidence?
Not to an employee side employment attorney, it is not. Um, look, it is very common and it's quite alarming for an employee to be put on a PIP, especially after they've experienced some health challenges. So I would say start to document everything. Get clear on what the objectives are, what the employer is looking for. The parameters in the PIP need to be clear, and start documenting. And if there are any verbal conversations, follow up with an email. We discussed XYZ in our meeting today. Thank you for your time. Document and save a copy for yourself, and certainly get some legal advice if you think that, if things don't quite feel right.
So my employer says my position was eliminated while I was on leave. Can they do that?
Employers have carte blanche to do really lots of things, right? So does an employer have the right to eliminate the position? Yeah, certainly they do, unless it's for an unlawful reason. So we start to look at all the factors. How long was the leave? How did the leave go awry? Who else was affected? Was that person replaced? And asking those questions of the employee, then we start to form a picture so the employee can know, like what are the next best steps to take.
So if I take leave for a good reason, I'm pregnant, or I have, some issue, my ear just fell out. I hate that when my ear falls off. Okay, and it's a one of the classified groups, and I and things just kind of get strange when I come back. Um, what what rights do I have before anything bad actually happens?
Well, we always have rights in the workplace. Sometimes they're very thin, but we always have rights in the workplace. I guess it's important to know what the employee's goal is. By the time we get a phone call, the employee's already out the door, they're ready to leave, or they want to know how they can best protect their job because they're worried about not having a paycheck. So knowing that goal first, then we can help the employee achieve that goal. If it's an exit strategy, we can help the employee negotiate that. Or if it's just advice on how to best protect themselves, we do that too.
Are there ever any damages for somebody getting fired in an illegal way or improper manner?
Yes, so the law provides damages as lost wages damages because of the employer's unlawful conduct. The employee has lost wages. There are also compensatory damages, those mental anguish and emotional distress damages that are available associated with the job loss. And there are also attorney's fees. And that is usually what makes employers perk up and pay attention to employment claims because there are those attorney's fees available for employment claims.
So people assume employment lawsuits take forever and cost a fortune. What's the reality for the average person who comes to you?
Well, they can take forever because of that EEOC process, which does take months. But we handle most employment cases on a contingency basis, meaning the employee doesn't pay until the case is over, case is resolved, either in settlement or in a judgment. And an employment case can take anywhere from a few months to 2.5 years, just depending on whether that lawsuit gets filed and how long that lawsuit continues.
So somebody comes to you, I mean, since you work on contingency for the most part, then you really have to be very direct about whether somebody has a case or not.
Yes, we're very selective because our time is limited. And, really, my, uh, when I take a look at a case, I look at the likelihood of my client being successful in a lawsuit. If they're likely to be successful in a lawsuit, we will look at filing that case. If it's difficult because of the set of facts or the status of the law, most likely it's a very high burden to meet some of these um, elements in these legal claims. It becomes very difficult, and that's a case we may consider not filing.
So you're serving as president and make sure I have this right, as president of the Como County Bar Association. What's the issue in employment law right now that you think deserves more attention than it's getting?
I think the issue of proper medical leave administration deserves more attention from employers. There are many people who have medical statuses that qualify as disabilities under the Americans with Disabilities Act. And I find that human resources employers, like I said, most want to do the right thing, but they are administering medical leave in an improper way, not having the proper dialogue with the employees, and it could be to the detriment of their company. So that's what I see is lacking with employers these days.
So you built a solo practice to serve people in one of the toughest moments of their lives. What keeps you at this?
Well, so it's a little cheesy. The mission of my firm is because everyone deserves to earn a livelihood free from discrimination and wrongdoing. And I mean, I've been fired before. I deserved it. But to but to be fired for through no fault of your own and to face not having a paycheck, not being able to pay your bills or not being able to buy groceries, that's very frightening. And it's something that people face, and it's a scary time for people. Our legal remedies are not fast, but there are there are rights. Employees are entitled to legal rights, and we're here to enforce those rights because it's important. It's important.
So if someone in South Central Texas is watching this and thinks that Lorna Griffin sounds like just the person I need to talk to, what's the best way they can reach out to you?
So our intake assistant, her email address is info@lgriffinlaw.com. That's info@lgriffinlaw.com. She will review your case, take a look, let you know whether it's something we can help with, and schedule some time with me to review your options and next steps.
Okay, Lorna, thanks so much for coming on the show. I think we're going to wind it up right here.